Good evening. Welcome to the University of St. Thomas. I am Dr. Terry Nichols. I'm a professor in the theology department, and I am one of the co-directors, along with Dr. Adel Ozdemir, who's out here in the audience, of the Muslim-Christian Dialogue Center here at St. Thomas as part of the College of Arts and Sciences. Our center, along with the Terence J. Murphy Institute, are co-sponsoring this event tonight. I'd like to say just a few words about the work of our Dialogue Center, and then I will turn the floor over to Professor Lisa Schiltz from the Terence Murphy Institute. Our mission at the center is to foster understanding and cooperation between Muslims and Christians through academic and community dialogue grounded in the Quran and in Christian traditions. This dialogue flows from our belief that Muslims and Christians worship the same God who is at work in both faiths. We regularly sponsor lectures, panel discussions, student discussions on Muslim-Christian dialogue. We have some flyers outside on the table, and we have a website that you can check, stthomas.edu/MCDC, which lists our events. Normally we have 3 or 4 events a semester. This is the 4th event we've sponsored this semester. We've also opened up dialogue with 2 Muslim universities, so our theology department and through our center, and Muslim theologians in Izmir, Turkey. We've met twice with them now, and one of them is here tonight, and some will be coming over in February. Our last meeting was discussing religious freedom. And we've also opened up a dialogue with theologians from the Al-Mustafa University in Qumran, which was dicey, pretty difficult to arrange, but we did it. We met with them last June 6th through 9th in Rome. They couldn't come here, and it was difficult for us to get there, but we did begin a dialogue, which we'll be continuing with them in next June. We hope to meet with them in Qum. So that's a little bit about our center. You can find out more from flyers outside. With that, I'll turn the floor over to Professor Lisa Schiltz from the law school, who will introduce our speakers. Thank you.
Hi, welcome. I'm Professor Lisa Schiltz, and I'm the co-director of the Terence J. Murphy Institute for Catholic Law, Thought, and Public Policy. That institute is a joint venture between the law school and the Center for Catholic Studies. And we are delighted to be able to cooperate with the Center for Muslim-Christian Dialogue in presenting this program as part of our series, Hot Topics, Cool Talks, where we explore Catholic perspectives in dialogue with other faith traditions on issues that can sometimes generate hot talk. Tonight, we have 2 speakers who are going to engage in cool talk on a very hot topic. Professor Vischer is currently the Associate Dean for Academic Affairs at our law school. His scholarship explores the intersection of law, religion, and public policy, with a particular focus on the religious and moral dimensions of professional identity. His forthcoming book, just hot off the press from Cambridge University Press, is Martin Luther King Jr. and the Morality of Legal Practice, Lessons in Love and Justice. That book pushes back against the individualist premises underlying our modern conceptions of the lawyer's rule by exploring Dr. King's vision of the beloved community. His earlier book, also Cambridge University Press, 2010, Conscience and the Common Good, Reclaiming the Space Between Person and the State, defines and defends the relational dimensions of conscience and identifies ways in which our legal system could better maintain the communal values in which the dictates of conscience are shaped, articulated, and lived out. Professor Vischer is a frequent commentator in journals such as Commonweal and First Things, and in spring of this year published an article in First Things that was entitled The Dangers of Anti-Sharia Laws. His dialogue partner today will be Professor Kwalili, a native of Somalia, currently adjunct associate professor teaching Islamic law at the University of Minnesota Law School. He's an expert in the areas of comparative constitutional law, Islamic law, international law, and the rule of law. Professor Kwalili received advanced degrees in law from the International Islamic University in Islamabad, Pakistan, and from the University of Minnesota Law School. Prior to his studies in law, he was a researcher at the Islamic Research Institute, a leading Islamabad-based think tank. Professor Kwalili was the founding chair of the Somaliland Law Reform Commission, focusing on rebuilding the rule of law and transitional justice in post-conflict environments. He was recently appointed by the government of Somalia to be a member of the National Select Technical Committee overseeing the approval of the new constitution by the National Constituent Assembly and the appointment of members of the new Somali parliament. He's a leading authority on the merger of Islamic law and the Anglo-Saxon legal system, a frequent guest speaker at universities and colleges, and a commentator in local and international media outlets such as BBC, Voice of America, Minnesota Public Radio, the Star Tribune, and the Associated Press, among others. So we are in for a real treat, having two experts in this kind of dialogue conduct this kind of a dialogue on this important topic for us tonight. Please join me in welcoming both of our speakers tonight.
Thank you. I appreciate the invitation to be here, and I appreciate the inclination of the organizers and both these centers to hold an event like this. It's an important topic. Let me be clear at the beginning, I'm not here as an expert on Islam, much less an expert on Sharia. It's important we hear from an expert on Islam, and that's why it's absolutely essential that you'll be hearing from Professor Khalile in a few minutes. I'm here to talk to you, though, as a Catholic and as a lawyer who is committed to religious liberty in a very robust and meaningful way. And my commitment to religious liberty is part of an even more foundational commitment to the intrinsic and inescapable dignity of the human person. The reason I say that is because it's important to note, in my view, that religious liberty is not primarily about winning the political debate over which groups get to maintain their chosen ways of life in the face of majority opposition. Rather, religious liberty is an anthropological claim about the nature of the human person. As such, it should not be left vulnerable to popularity contests. So to give it some context, let's consider the battle currently raging over the HHS contraception mandate. All right, one frequently cited statistic is that 98% of Catholic women will use artificial contraceptives at some point in their lives. Putting aside questions over the validity of the statistic itself, my question is, what does the popularity of the Church's teaching tell us about the legal standing of the Church's institutions to live out those teachings? As we witness the growing popularity of social norms espousing the centrality of individual autonomy or the categorical unacceptability of any sort of discrimination in the provision of any goods and services, we are also witnessing, and I don't think it's a coincidence, we're also witnessing a weakening of our commitment to religious liberty. So by way of very brief illustration, the law in several states now requires a Christian physician to provide reproductive assistance to a patient regardless of her marital status, requires pro-life pharmacists to dispense the morning after pill, requires a Christian wedding photographer to photograph a same-sex commitment ceremony, and requires Christian adoption agencies to place children with same-sex couples. Some state laws aimed at illegal immigrants appear to prohibit churches from ministering to the human needs of those immigrants. Public universities have revoked recognition of Christian student groups who require their leaders to be Christians. The list of what are, in my view, violations of religious freedom keeps growing. Religious believers are fine if they keep their beliefs private, but permitting those beliefs to shape public square conduct is an increasingly dicey proposition. The contraception mandate, for example, exempts religious organizations who employ and serve members of their own faith, but not religious organizations who serve or employ others. The ministry of Jesus himself would not qualify for an exemption. So if religious liberty is a popularity contest, we may be in trouble unless we're willing to keep our religious beliefs out of the public square. In my view, Christians should be strongly resisting this trend, and many are. But many are unwittingly supporting this trend by attacking the liberty of the religious believers who are least well-positioned to win any popularity contest in America today. Proposals in state legislatures across the country aim to keep Muslims' beliefs out of the legal system by prohibiting courts from relying on Sharia. These so-called anti-Sharia initiatives are just the most politically popular example of the expectation that religious faith is a private matter, not suitable for public airing in a civilized society. Anti-Sharia legislation does not defend against theocracy, but calls into question our society's fundamental commitments to meaningful religious liberty and meaningful access to the courts. These commitments have been relied on for generations by Protestants, Catholics, Jews, and Mormons, and to try to remove them for Muslims is both unjust to Muslims and sets a dangerous precedent for their use by other religious groups. Now, Sharia is a broad and diverse legal code that governs everything from how to contract a marriage to how to prepare a meal. Proponents of the anti-Sharia legislation tend to focus on extreme manifestations of Sharia overseas, the stoning of adulterers, cutting off the hands of thieves, and denial of basic freedoms for women in some Islamic countries. On American shores, the targets of concern are, to say the least, elusive. One commonly cited case, for example, was brought by a Moroccan woman in New Jersey who sought a restraining order against her husband for repeatedly assaulting and raping her. The state trial court judge denied the request for a restraining order, finding that the husband lacked the required intent because he believed that the wife's compliance with his demand for sex was mandated by Islamic law. The decision was overturned on appeal, as it should have been. This single case, cited constantly by proponents of anti-Sharia laws, is not evidence that Sharia is taking over America. A lower court judge made a mistake, and that mistake was corrected on appeal. Our system worked. Other cases that are included in the anti-Sharia arsenal are even weaker. One is from Pennsylvania, where a state court judge dismissed an assault case against a Muslim man who allegedly attacked another man who had dressed up like a zombie Prophet Muhammad for a Halloween parade. The Muslim man admitted to arguing with the complainant, but since there was no proof that he actually touched the complainant, the judge dismissed the case. At the hearing, the judge chastised the complainant for his choice of costume. Whether or not it was appropriate for the judge to chastise him in this way, I have a hard time seeing how the chastisement amounts to an embrace of Sharia. Nevertheless, the headline on the websites reporting the case reads, "Pennsylvania judge's ruling, proof of Sharia law in U.S. courts?" ? Apparently framing it as a question gives one fairly wide berth with the facts. Sharia literally means the way to the watering place. It has come to refer to the correct way of practicing religion, in particular the rules that govern the lives of Muslims. There are many schools of interpretation among Islamic legal scholars that I am not even remotely qualified to enter into. On certain teachings, some interpretations stand in considerable tensions with the rights that we have come to take for granted in liberal democracies, including the rights of women, gays and lesbians, religious minorities, and religious converts. Hence the firestorm that was provoked in 2008 by the Archbishop of Canterbury's recommendation that space be afforded in the British legal system for some aspects of Sharia. What is often overlooked about the Archbishop's speech is his ringing affirmation of the rule of law. He explained that beyond affording space to groups to live out their values and commitments, the political community must also maintain space, quote, accessible to everyone in which it is possible to affirm and defend a commitment to human dignity as such, independent of membership in any specific human community or tradition, unquote. In other words, the political community need not stand by silently without regard to whatever interpretation of religious law emerges from a given community. Fears about the most extreme applications of Sharia need not prompt a categorical ban on Sharia. Secular legal norms can serve as boundaries within our legal system without closing off access to norms that are imported from outside the legal system. This distinction is largely lost on anti-Sharia advocates. Despite, or perhaps because of, these advocates' propensity to avoid any such nuance in their political rhetoric, the anti-Sharia campaign has gained substantial mainstream traction. 70% of Oklahomans, 70%, voted in November 2010 to amend the state constitution to forbid courts from considering, quote, international law or Sharia law, unquote, in their decisions. The amendment's popularity, of course, did not ensure its constitutionality. A resident of Oklahoma sued, pointing out that the amendment would preclude courts from probating his will, which contained references to Sharia. The federal district court issued a preliminary injunction against the amendment's enforcement, a decision which was upheld by the federal appellate court earlier this year. That amendment was doomed by its singling out of Muslim citizens. It banned legal reference to Sharia without banning comparable systems like canon law or Jewish law. The appellate court observed that if a law discriminates among religions, it can only pass constitutional muster if it is closely fitted to a compelling state interest. The lack of such an interest was underscored by the defendant's own admission that they did not know of, quote, even a single instance where an Oklahoma court had applied Sharia law, let alone that such applications or uses had resulted in concrete problems in Oklahoma, unquote. Despite the demise of the Oklahoma law, the anti-Sharia banner was picked up by Republican presidential candidates in this election cycle. Newt Gingrich identified Sharia as a mortal threat to the survival of freedom in the United States, warning about jihadis who may avoid violence but who nevertheless are working to replace Western civilization with a radical imposition of Sharia. Rick Santorum and Michelle Bachmann signed a pledge to reject Sharia Islam and all other anti-woman, anti-human rights forms of totalitarian control. And Bachmann explained that Sharia law certainly does not have a place in a United States courtroom. Even Mitt Romney felt obliged to insist that, quote, we're not going to have Sharia law applied in U.S. courts, unquote. Before Christian and Jewish believers support such measures, they should consider the way they threaten their own religious liberty and misunderstand the faith of their fellow Muslim citizens. Muslim Americans who seek to use Sharia are not asking the American legal system to adopt Islamic rules of conduct, penal or otherwise. Muslims who have introduced Sharia in court in an attempt Muslims have not introduced Sharia in court in an attempt to establish Sharia as a freestanding source of law binding on litigants, but rather in recognition of the norms to which they themselves have already agreed voluntarily to be bound. American courts do this every day. That is, enforce agreements to which litigants have themselves agreed to be bound. There's a whole field. It's called contract law. Even the literature being pumped out by anti-Sharia organizations shows that their target is not the threat posed by the imposition of Sharia on American society, but rather the perceived threat posed by the introduction of Sharia according to the same criteria of admissibility applied by courts to other religious codes. So let's give some examples here. The disputes implicating Sharia tend to crop up over the terms of the contract that comprises the litigant's marriage. Now, my understanding is that in Islam, the contract does not precede the marriage, the contract is the marriage. The disputed terms often pertain to the distribution of property upon marriage and in the event of divorce or the husband's death. American courts do not rubber stamp all marital contracts. But whether or not a contract formed in accordance with Sharia is enforceable should turn on whether it goes beyond the contractual conditions that would be tolerable in any marital contract, not on the fact that it emerged from a particular religious system. More broadly, the religious terms of an agreement do not preclude its enforcement by courts. If a Baptist church's rules provide that a pastor can only be removed by a vote of the entire membership, a court will uphold a pastor's challenge if he was dismissed without the required vote. The fact that the church's rule expresses the Baptist commitment to the priesthood of all believers does not preclude a court from enforcing it. To ban Sharia or any other form of religious law puts religious citizens at a tremendous disadvantage. The rules of the PTA, the ACLU, or the Humane Society all have real authority because the legal system stands behind them when disputes arise. American law rightly stands behind the rules adopted by religious bodies unless those rules conflict with important public policies. Courts are not going to enforce a Mayan rule about child sacrifice, but in the vast majority of cases, courts enforce religious rules. When bankruptcy courts apply canon law in determining property rights for a diocese, or when courts enforce arbitration agreements based on biblical principles pursuant to widely invoked rules of Christian conciliation, the rule of law is not jeopardized. Anti-Sharia legislation proposes an unconstitutional double standard. Canon law and biblical principles are not dirty words in the American court system, and Sharia should not be either. Though the political will behind the anti-Sharia movement remains strong, translating that force into legal reform has become complicated. Perhaps learning a lesson from the Oklahoma debacle, anti-Sharia advocates have become stealthier, though the subtlety of the new initiatives makes it unclear what the advocates actually hope to accomplish. A bill recently proposed in Michigan, and this bill has been widely replicated elsewhere, tries to avoid the constitutional pitfalls with a broadly worded provision that a court or administrative agency, quote, shall not enforce a foreign law if doing so would violate a right guaranteed by the Constitution of this state or the United States. And then foreign law is defined as any law, legal code, or system of a jurisdiction outside the United States. The bill has more than 40 co-sponsors, but its primary proponent has made clear that the bill aims at Muslim litigants who, quote, do not want to be under our law. This past May, for one more example, the Catholic governor of Kansas signed nearly identical legislation and made it the binding law of the state. In all likelihood, this second generation, sort of anti-Sharia 2.0, will not change judicial practice because they only ban the enforcement of foreign law that would result in the violation of a constitutional right. American courts are generally not in the business of issuing rulings that violate the litigant's constitutional rights. If a foreign court order is entered without a party having the chance to contest it, or if the foreign procedures lack fundamental fairness in some other way, American courts will not enforce the order. If a contract is based on foreign law, but the contract is entered into through coercion or duress, our courts will not enforce its terms. The source of the substantive terms of the court order or contract, whether that source is Canadian law, canon law, Sharia, or the Bible, does not determine the enforceability. Even though the First Amendment has now forced anti-Sharia advocates to frame their proposed laws so broadly as to be, in my estimation, meaningless, these initiatives should be vigorously contested by religious liberties defenders. When state legislators across the country line up behind such bills, the aim is not primarily legal reform. It is political grandstanding aimed at reassuring nervous constituents that Sharia law will be kept out of our country. This serves only to fan the flames of religious intolerance while nurturing public acceptance of the notion that the religious commitments of our citizens have no place in our courts. Law has a pedagogical function, and anti-Sharia laws harm the social fabric by its very premise. The presumption that religious Americans' deepest core values and convictions threaten the legal order by virtue of their source without reference to their substance. When I've spoken or written before on this topic, I've tended to get a lot of responses, and anti-Sharia advocates have often accused me of misunderstanding the nature of Islam and Sharia. As just to take one writer who responded that, quote, the world has never seen a form of Sharia that has not been extreme, and so the only objective of their anti-Sharia movement is to prevent this authoritarian and oppressive political and social system from eroding the freedoms we enjoy as Americans. Now, I don't believe this interpretation of Sharia is accurate, but I'm going to defer to others on that because I'm not an expert. But I don't need to be. Right? Whatever dangers Sharia could potentially pose for America, we have to show confidence that the American legal system is strong enough to address those dangers as they arise without banishing an entire faith tradition from participation in our public life. Stoning adulterers is wrong and should be banned, regardless of the source of the motivation for the stoning. Once we permit law to focus on the source of motivation for conduct, rather than the conduct itself, the rule of law is compromised and religious liberty is headed for some very dark times. So rather than wait to see whether the next iteration of the anti-Sharia movement passes constitutional muster or even changes judicial practice in any meaningful way, the better course is for Christians and other religious believers to stop the movement in its tracks by reaffirming that American courts are open to religious believers and the norms to which they voluntarily bind themselves on equal terms. Freedom of conscience is not just freedom to believe, but freedom to apply that belief to conduct, to act in accord with one's conscience. Liberty to live consistently with one's beliefs may bring one into conflict with others, especially in a society increasingly convinced that religion is corrosive to the common good. But that is one of the prices of protecting religious freedom. and one that can only be adjudicated through our law and the democratic process. We must remind our fellow citizens that the only alternative to a robust, action-oriented liberty of conscience is what Charles Taylor calls a privatized, personalized conscience that amounts to meaninglessness. When the state encroaches on the venues in which people live out their core beliefs, including the legal venues in which those core beliefs are given real-world efficacy, the cause of conscience suffers. A secularist vision of the public marketplace is increasingly excluding traditional Christians, or at least requiring traditional Christians to defy their own commitments as the price of admission to the marketplace. It would be a sad irony for Christians to be complicit in the effort to do the same to American Muslims. Thank you.
Good evening. Well, I must admit, before I do that, I would like to thank the University of St. Thomas for inviting me to this important discussion, which I think is a very fundamental one to have in an institution like this one. But I must admit, first of all, that I agree with everything, or almost everything, that the professor has said. He has done a great job, I think, in laying out the case against anti-Sharia crowd, as I refer to them. Before I start my few remarks here, I would like to know how many of you have heard about the word Sharia before coming to this evening's discussion. Can you raise your hands? Okay, wow. It seems that what the professor has discussed really opens the door to few things, or what I call facts, that I would like to share with you tonight. Because he has spoken about the situation and conditions of anti-Sharia campaign in the United States, how it's contrary to the freedom of religion guaranteed by the US Constitution, and how it's an infringement upon the religious freedoms of Muslims who are integral part of the fabric of the United States of America. What I would do in the next few remarks here is I would talk about Sharia itself. And I would stand here before you tonight to share those facts with you because I see a lot of misconception. I see a lot of misinformation, willful misinformation perpetrated by a variety of groups about this very important issue, the Sharia. So the question is, what is Sharia? Sharia is an Arabic term that refers to the code and the religion of Islam in general. Sharia is based on two fundamental sources. The first source, which is the book of Islam, the Quran, the revelation from God to Prophet Muhammad. So the words of God, as compared to Prophet Muhammad, constitute part of Sharia. That's the first source of Sharia. The second source is the traditions of the Prophet Muhammad, being the exemplary person and the one who embodies the will of God on this earth. Whatever he has said, did, or approved in his lifetime is considered Sharia. And people always mix up between Sharia and Islamic law because there's a difference between the two. Sharia, as I said, refers to the combination of those two primary sources, the Quran, which is the sacred book of God, and the Prophet Muhammad's traditions, the fundamentalists of Islam. So when we refer to Sharia, in fact, we are talking about Islam itself. By definition and in technical terms, it's Islam. And it's different from the Islamic law, or what we call fiqh, or jurisprudence, Islamic interpretation. Because Islamic law constitutes only a component or a part of Sharia, but it's not the Sharia itself. Sharia is much larger than that. Sharia is a very complex code, as I said, that deals with anything and everything that a Muslim has to carry out in his or her lifetime. Anything from how to eat, how to marry, how to transact any kind of transactions, how to distribute estate after death, and so on. Basically, the entire life of the Muslim rotates around the Sharia itself, and it regulates that, even how it deals with Muslims and non-Muslims, and how it deals, and it regulates the relationship between nations. It has a discussion and a reference to the morality, to the mannerism, to the ritualistic actions that Muslims carry out to worship their God. It is part of the how to create relationships between communities. So it basically is a code that refers to more than what we know as a law. So it goes beyond that. And Sharia being therefore such a comprehensive term referring to Islam itself, you can then realize how dangerous it is to discard and denigrate the term Sharia itself, because it is Islam itself. And the misconception comes from many people who willfully, I think, try to concentrate on aspects of Islamic punishments as contained in the Islamic law. Because Islamic law is of two parts. One that's laid out in the Quran and the traditions of the Prophet, most of which is immutable and contains certain punishments that are considered very harsh today, or may be contrary to the norms of human rights and Universal Declaration of Human Rights. And it contains also parts of punishments and laws that are subject to the interpretation of the mankind and human being. So Islamic jurisprudence has developed, therefore, as a man-made attempt to interpret the law of God as found in the Quran and Sunnah. That's why you have different schools of jurisprudence in Islam. And that's why you have scholars who came out throughout the centuries to interpret the will of God. And their opinions, which later on was adopted either as a form of volumes and are spread throughout the Muslim world and are implemented in courts, are not the words of God. Rather, they are the human interpretation of the sacred text of Islam. Therefore, Sharia is a reference to that general Islamic ideals and general Islamic principles and Islam itself. That's the fact number one. So Muslims being at least 23% of the entire mankind on this earth, over 49 countries with Muslim majorities, you can just imagine how an antagonism towards such a deeply held beliefs of such huge number of people is really problematic. And I would think that one would do a prudent research to understand what this code, what this term Sharia means, rather than relying on sound bites by the anti-Sharia crowd on the media. The second fact that I would like to share with you is that Sharia, or Islam, is enshrined in the constitutions and the legal documents of many countries in the Muslim world. There are numerous constitutions in the Muslim world, including the one in Pakistan, the constitution of New Egypt that's being drafted at the moment, the one in Somalia, and many other Gulf countries that specifically says Islam is the source of all legislations in the country, and the official religion of the country is Islam, and therefore making it the leading or the guiding principle of the constitution of those countries. Some countries' constitutions go even farther and say that any laws that are contrary to the injunctions of Islam as found in the Quran and traditions of the Prophet are unconstitutional. Those include big countries like Pakistan. And so the Sharia itself is an integral part of the legal documents, including the constitution and statutes of many Muslim countries. And it would be problematic, therefore, to disregard that kind of code, which is held in such high esteem by many countries, disregarded as though it is a code that's followed by a cult, as some would like to call it. The third fact is that United States of America does not live in isolation. We are part of a global world. And given the globalization, issues such as marriage, corporations, divorce, custody, and so many other issues are in fact global issues these days. And the United States courts are bound to encounter cases that involve those globalized issues. You have just heard cases that involve with custody. I think a case that's highly misused and used as a poster child, if you will, of what's wrong with Sharia. There are cases where the United States government, the United States courts in numerous jurisdictions considered and respected the foreign law, not as a law that the United States has to be subject to, but rather to understand the conditions, the facts of the case, and what the litigants want. And therefore, the US courts in respecting those foreign laws, including Sharia, are not free in their discretion. Rather, those discretions are dictated by the United States law. So when they, for instance, look at a contractual obligation by litigants that involve Sharia, one of the things they will do is make sure that it doesn't contravene with the settled and established principles of the United States law. So the Sharia as a foreign law, just like any other law, that of the UK or France or any other law, being sometimes considered in US courts, is as much a threat to the Constitution of the United States and the laws of the United States as the Bible is. If the Bible is a threat to the US Constitution or the law, then Sharia would be. Because there is no attempt. The true reality and the true story of Sharia in this country is that there is no attempt to impose Sharia, nor has there been any verifiable effort by any group or individuals to substitute Sharia with the United States laws and Constitution. And Muslim Americans, being faithful citizens of this country, understand the fact that there is something called separation of religion and state in this country. The Establishment Clause in the United States Constitution is very clear, and they adhere to that. But there are some relationships that go beyond the borders of the United States. If a Muslim marries another Muslim in a country that is subject to Sharia law, those cases will spill over and will certainly end up, or may end up, in US courts. And the US courts, in considering those laws, doesn't mean that they are applying Sharia. It does mean that they are giving due respect to the facts and agreements that's between the parties. There was a celebrated case where ExxonMobil, the oil giant, and a Saudi company entered into a contract. Among the clauses of the contract was that, should there be a dispute, the Saudi law, which is based on Sharia, will be the one to resort to in order to resolve such dispute. The Superior Court of Delaware, which handled a dispute between the Saudi company and ExxonMobil, considered the fact that there was an agreement between the two companies in case of dispute to resort to Sharia. And in upholding that agreement, a jury awarded $40 million to ExxonMobil because it considered that these were freely entered into a contract and agreement, and that it hasn't contravened or it didn't contradict with the principles, established principles of the US laws. And had Sharia ban been in place, had the anti-Sharia crowd succeeded in banning Sharia from US courts, ExxonMobil would probably have been wouldn't have succeeded $40 million from the Delaware jury. So the fact is, there is more than a threat or a perceived threat behind the crowd, the anti-Sharia crowd. In fact, one of them, and we've just heard some high-profile politicians who politicized the Sharia and willfully antagonized the Muslims in this country. But one of the proponents of this anti-Sharia campaign actually made it very clear what his motives are. He has said, and I quote, and he was referring to the numerous legislative proposals introduced in numerous legislative houses from the South all the way to Minnesota, where we almost had a proposal. I mean, strangely, one of our local lawmakers came up with a proposal that he wanted to introduce in our legislature here, banning Sharia again. I think dancing with the other crowds elsewhere. Well, one of the people who are behind this, a person referred to as the man behind the anti-Sharia movement, he's an attorney, I think, down in New York, openly admitted that his anti-Sharia campaign has ulterior motives that goes beyond the statutes themselves. He actually said, referring to those legislations or proposals, and I quote, "If this thing passed in every state without any friction, it would have not served for this purpose. The purpose was to get the people asking this question: what is Sharia? This question was meant to render Muslims suspect and their faith threatening to the rest of us." That's his stated goal behind mobilizing and galvanizing so many campaigns and people to go against Sharia. And this just shows you that it's a highly politicized attempt. The bad news is that people actually believe that. They believe this hype, and many people ended up believing those things. In a 2011 poll by the Public Religion Research Institute showed 30% of Americans believe Muslims want to establish Sharia in the United States. 30% of the United States population thinks, according to this survey, that Muslims want to, in fact, establish Sharia in the United States. In fact, the percentage was much higher. It was up to 52% among those who said they must trust a particular television news channel. And now, if you think that up to 52% really believe this hype, I mean, we really have a serious problem in our hands here. Because, as I said, Sharia is Islam, and Islam is Sharia as such. And if you denigrated the Islamic faith itself, faith that's held, as I said, by 1.6 billion around the world, 23% of the world population, then I think it's against the public policy to really deal it with such simplicity and superficiality. And therefore, I think that the movement here is not going to reach its goals, because the US, the United States of America, was built based on solid principles that protect freedom of religion. This country is about freedom. And in no other place would you find such freedoms of religion upheld at all levels and by the basic documents governing this country, including the United States Constitution. So while these are very trying times for Muslims in America, while these are very difficult times for Muslims around the world in their relationship with the United States, I think the basis of the relationship between the US and Muslim world is in fact based on much more solid grounds. The bridge of understanding and cooperation is much more solid than this noise that you hear, this hype that you hear about Sharia. And I think as the time passes, it will become very clear that Muslims and the United States people share more than they have of difference. And I think people will realize that Sharia is not a code that's held by a cult. Rather, it's a religion, one of the great monotheist religions that has as much in common with Judaism and Christianity, and that Sharia itself was unfairly reduced to a code of punishment, a penal code. Issues such as stoning to death or chopping off hands of thieves, which are a tiny, tiny minority of the Islamic criminal law itself. For instance, there hasn't been any case where, when you look at the evidentiary threshold, for instance, required for this event, for inflicting this kind of punishment, it's almost impossible to apply. And therefore, it is said by scholars that they are there for deterrence, just to deter people from committing crimes. And that's why you haven't seen any cases of such extreme hardship, extreme punishments imposed throughout the Muslim history. With that, I would like to conclude my remarks and would let you to have the Q&A session and elaborate this, I think, topic, which is very important in that session. Thank you very much.
Before we open the microphones up for questions and answers, we would just like to give our two dialogue partners the opportunity to have a couple of minutes if there's anything that you want to say about each other's remarks. And then we'll have people come up to the microphone if you have a question and pose your questions directly to our speakers.
Well, is this on? No. Well, I'll speak loudly. I'm largely in agreement with everything. There's one area of tension. So emphasizing the degree to which Muslim or some Muslim majority countries have embedded Sharia in their constitutions is certainly a reason why a ban on Sharia is complicated in American courts given international law norms, but it is also part of the root of the fear surrounding Sharia from some American citizens who say, well, you see what they do over there? As soon as they overthrow Mubarak, then it all becomes about Sharia. And if the reason Muslims are not doing that here is because they currently can't. But it's really just a function of political power rather than a principled commitment to separate Sharia from the governance of a pluralistic, democracy like this. And so I think there is some tension there, and I don't know enough to really wade into it, but there's some tension there where some folks would say, yeah, exactly, that's in the constitutions over there, and that's what they're going to try to do here, I think. That is my only point of maybe there's more discussion that's needed on that point.
If I may comment on that. Okay, can you hear? Okay, good. Well, let's take the example of Egypt, for instance. Countries in Muslim world, as I said, some of them do have clauses or provisions in their constitutions that say that Islam is a source. And in some you will find a reference as the source of all legislations. The Egyptian example that you just mentioned is far more different than few examples that people used to sometimes refer to. I think what's fixated in the minds of many in the United States is the experience of the Taliban in Afghanistan, for instance, who have a very extreme version and interpretation of Islam. Many Muslims and Muslim scholars, highly credentialed Muslim scholars, did object to the way Taliban, for instance, applied the Islamic punishments, which really have become, I think, a very problematic for many Muslims because of the fact that people were not accorded a due process in those cases. What the fact is, the constitutions do regard, as you said, the Sharia to be integral part. But we don't see people being stoned to death in Egypt or in Tunisia or in Syria or in Yemen or in so many other countries, including Pakistan and Turkey. What we have is Muslims who are trying to create a hybrid system, a system that comprises democratic values, as we find in our contemporary world, as well as the principles of Islam. In other words, what some refer to as Islamic democracy, which creates a system, a compatible system between Islam and democracy. So if, for instance, recently I was involved in the constitution making of Somalia. Big debate was what would be the position of Islam in the new constitution. Some people said we have to adopt a system that's entirely based on Islam, and we should not incorporate any values from the global legal systems and human rights and rule of law values and norms. But later on, the consensus was that while Islam should constitute the basis, guiding principles and founding principles of our constitution, nonetheless, we have to also incorporate the experiences, the successful experiences of other democratic countries that really have no contradiction with the basic rules and principles of Islam. So while I understand that some may say, look at those countries, look what they are doing, we don't want that imported to our shores and to our courts, the reality is that those are also extreme examples, even in the eyes of Muslims. And they do not represent the true Sharia. They do not represent the true, robust, comprehensive, and ideal implementation of Islam. In many countries, Islam is implemented to a varying degrees. There are countries that adopt Islamic commercial law. Others have confined Islamic law only in the area of family law, and others have, adopted at various degrees. But in general, Sharia is a reflection of the aspirations of Muslim people, and that's why you have seen in every country in the post-Arab Spring, when people went to polls, they have elected groups with Islamic tendencies. And the reason is that those Islamic groups reflect the values of the population. And I think the choices that we see subsequent to in the aftermath of the Arab Spring is that Muslims prefer democracy over dictatorship, and they prefer a civil system, a system that's based on pluralism, over a system that is rigid and ideologue. And the new constitution of Egypt itself also, again, is another example where there's a big debate also and a big compromise, basically protecting the rights of minorities, including Christian Coptics in Egypt, and other civil rights and freedoms and basic liberties. So I think Muslims are now in transition, and there is a ongoing process of transition from dictatorships to democracy. And along that transition, there will be so many mistakes and different examples. For instance, if you go to some Muslim countries and then visit a different country of another Muslim country, you may not even recognize that you left from one Muslim country to another, because so many issues are also reflected in the local customs and how people apply Islam, how they understand. So local cultures play a big role as well. So I certainly agree that some people may use those examples, extreme examples, as a point of really a source of concern. But I think those examples, the Taliban example or Al-Shabaab example in Somalia, are not representative of the mainstream Islamic values and mainstream Islamic principles and interpretation.
I have a question for Professor Holland. Could you comment on the room in Sharia for religious freedom of non-Muslims?
Well, Quran is very clear about the freedom of religion. It says in one of the verses that there is no compulsion in articles of faith. And in another verse it says that people are free. They could either believe in Islam or in God, or they could refuse to accept the message of Islam. So there are numerous verses in the Quran that specifically refers and establish freedom of religion. Islam there also creates an environment for a dialogue and peaceful coexistence between Islam and other faiths. It gives particular and specific, I think, privilege and consideration to the relationship between Muslims and Christians and Jewish heritage, those of Jewish heritage. For instance, in Islam, the Quran says that Muslims can marry a Jewish or a Christian woman, but not a person of other faith. It also allows and permits Muslims to eat the food and the meat that's slaughtered by a Jewish or a Christian person. And so when you look at, and the Quran also is very specific about the fact that it recognizes the doctrine and religious values of Christians and Jewish faiths as revealed and authentic religions revealed from God. And it considers itself as a completion of that message itself. And therefore, I think the freedom of religion is a well-established value and legal norm in Islam.
I'd invite other members of the audience to put questions to either one of our speakers.
So we heard that Sharia is synonymous with Islam,
That's correct.
and so you guys talked about how people fixate on the certain extreme portions of the law, and Rob, you mentioned that you think that the American legal system is capable of dealing with something like this, which I agree with. So I guess my question is, to what extent do you guys think being anti-Sharia is being anti-Islam?
Well, so speaking as a non-Muslim, I think that it's very hard to separate the legal rhetoric about anti-Sharia legislation from the political rhetoric about Islam, especially about radical Islam or perceptions of radical Islam, whatever that term includes. And so my perception is that some Americans feel relatively powerless to do anything about what they perceive to be as problems emanating from radical Islam overseas, so they do what they can, what is in their control, which means if there's something on the ballot that has to do with Islam, doggone it, we're going to vote for that because that's something we can do. So I think it is all wrapped up together. And I'm not saying that everyone who has ever voted for an anti-Sharia piece of legislation is anti-Muslim. I think that's too sweeping. I think there are some folks who have legitimate concerns about what Sharia represents. I think they're just misunderstanding what this legislation does and what it can do and what Sharia law means in the everyday lives of Muslims. So I'm not saying that everybody is bigoted against Muslims who supports these. I think a lot of folks are bigoted against Muslims who support these, but I don't think it's completely overlapping circles. But I do think that much of this is motivated from a broader geopolitical concern about what Islam represents, and this is just the way that we can react against that as Americans.
Well, I think I certainly agree with the statement that this is a reflection of a much larger geopolitical issues that face the U.S. And the perceptions that the United States, the people in the United States developed about Muslims following the September 11th as well, also plays part in that. And I think that the danger of this anti-Sharia legislations is that it is, first and foremost, against the values of the United States itself, the constitutional guarantees and liberties and rights, freedoms that are enshrined in the United States Constitution and Bill of Rights really go against this kind of selective targeting of a particular faith group because Muslims are entitled to the protections and equal protections that are found in the Constitution. And therefore, this attempts to really demonize their faith or consider their faith as if though, and I said again, Sharia is the Islamic faith itself. I think separating between the two is really an inaccurate reading of the word Sharia itself. And therefore, demonizing this faith itself, I think, is to the detriment of the freedoms that we enjoy here in the United States. And that's why I'm very appreciative of this kind of efforts to really showcase how misguided these attempts are. I mean, they, as I even indicated in my remarks, they have some sinister and cynical motives behind them, political motives and other motives. So I think this is a challenge. Again, it's a challenge to the very core principles that we hold so dear in this country, and standing up for those kind of anti-freedom of religion people, I think is something that's really expected of a prestigious institution such as St. Thomas University, faculty or academics here. And finally, I would say that the Muslims really, I visit Middle East and East Africa a number of times every year, and when people hear that there are movements to ban Sharia in the United States, they really are surprised. They think that what are the motives behind this? There is no chance that Muslims are attempting to impose Sharia or import Sharia into the United States, and therefore it's such a preposterous proposition, if you will, to even consider this as a serious. The problem is, as I said, the numbers are there. People are believing. People are internalizing this, and some people are accepting this as if it's a fact. And I think we need to debunk those.
I think you will agree with me that as Muslims living in the West, there is a perceived, or actually an actual, not a perceived, disconnect between Islam as we study it and Islam as is practiced. And that's not only overseas, but also here. And I hear that from several individuals who ask me as a Minnesota Muslim, when you speak about Islam, it sounds fantastic, sort of like when we speak about communism on paper. But in practice, there are so many areas where the practice does not reflect the teaching. This is one thing I would like to ask your help with. How do you explain to people that disconnect between the two? The second one is a remark on what Professor Murphy said before, which is the gentleman who said that there weren't any examples in history of Islam being other than, or Sharia law applied being other than extremist. And I will only refer to two very well-known periods, but I mean this is a very inaccurate. All systems have had periods of time when there is extremism, and then that recedes and more liberal thinking comes in, or more humanistic thinking. The two very well-known periods of time is the one we refer to as the golden age of Islam in Andalusia, in Spain, that even Abba Iban, who used to be we all know who Abba Iban is, who used to be the foreign minister of Israel, in his book, My People, or about the history of the Jewish people, has a chapter on Jews under Muslim rule. And the last part of it, if I remember correctly, he talks about never under Christian domination has the Jewish spirit risen and soared so much because of the symbiosis between the Muslim ideals and the Jewish ideals and all of their collaborative efforts and the civilization they produced for us, where their laws, including Sharia, we talk about Sharia as a way of life rather than Islamic law, but even the Islamic laws taught Europe what later on was translated into the Renaissance. So those are the two things. And then I'm going to say something a little humorous here from my own experience living as a Muslim in Minnesota. I don't think, I agree with you, Professor Murphy, that the courts are the places where this is going to be decided. And in my own life, I've had 4 instances, I only tell you about one, where Sharia law, if you will, or Islamic law, collided with American law, and American law prevailed at every time. The first time was right after I got married overseas. I was in England, he was in Egypt. My father represented me in the contract, which is permissible in Islam. I came here and I was told by the courts, you're not married. In essence, you're living in sin. I had to go to court in St. Paul and get another marriage because this is not recognized. If you're not present there, so that there is American law, overriding and correcting the situation. Another time was when I fell in love with a piece of parcel of land on the St. Croix River, and asked my husband, he wasn't interested in buying it, so I went and bought it with my own money, which is quite permissible in Islamic law. There is no such thing as the family pot, so to speak. I mean, they have separate economical entities, men and women. And then later on, we found the house on the St. Croix, and we didn't need that piece of land, so I was going to sell it. Went to the session with the realtor and the attorneys and what have you, and they said, where is Mr. Reda? I said, well, that's my last name. Well, first of all, Muslim women don't change their names, so which Mr. Reda are you asking about? My father is up in heaven, my uncle is I don't know where, etc. They couldn't understand why we don't change our names. That's a different story. And then I said, what do you want with it? They said, no, your husband. What do you want with him? Well, you cannot sell this piece of land without his permission. I said, I bought it without his permission. Why wouldn't I sell it without his permission? This is my money. They couldn't understand it. That's perfectly allowable in Islamic law. And I had to call him and say, honey, would you please come down? Because we need your signature here, or we're not getting out of here. So just,
And just a quick follow-up on that, so especially the marriage example, I mean, what that's really talking about are there circumstances where your religious commitment should entitle you to an accommodation from otherwise valid law. That's not even what we're talking about. We're talking about not letting Muslims be specially burdened because they are Muslims. It's a separate conversation that might be a worthwhile conversation at some point, where should Muslims, like others, be entitled to some accommodations from general laws, but to get to that point, you just have to get back to the level playing field where they're not going to be given special burdens. Because if you could enter a contract with somebody where the basis of some of the norms in the contract are your interpretation of the Harry Potter series, for example. And that doesn't invalidate it in any sense, but to say that if your interpretation is shaped in part by your understanding of Sharia, it is invalidated, that's not an accommodation. We're talking about unique and targeted burdens.
Yeah. And if I may also follow up on maybe 2 quick points. Number one is the disconnect between the Islam as a text, religious text, and the practice of Muslims, whether individuals or states. I think that's a very legitimate point. There is a huge disconnect sometimes, as I maybe indicated in my remarks here, between what Muslims do, which may not always be in conjunction with or reflection of the true Islamic values, and what Islam itself says. And there are many, many examples. Those who, for instance, are killing innocent children and non-combatants in Islam, in the name of Islam. That's in direct contrary to the established Islamic humanitarian law. The Prophet himself, in authentic traditions, has outlawed those kind of practices. But you will see Muslims who are engaged in those kind of actions in the name of Islam, most of the times for political purposes. And that should not be the responsibility of Islam. And I think it shares with other faiths and other ideologies where some people have their own interpretations and so forth. And so some Muslim countries, and as I must also add that, what we find in Muslim countries is that many of them do not, in fact, apply Islam as the law of the land. And they have laws and systems that are based on either Western systems or are heavily influenced by Western jurisprudence and legal systems. So, for instance, if you go to a country like Egypt or even before the Arab Spring, you would find that they had a law that was based on French law, and their statutes were based on other European laws. Syria is the same, Sudan before 1989, and so forth. So the question is, many of the practices that you see are not necessarily the true reflection of what the text of Islam says, the Islamic text says. And that,
At what point do you say, I'm a Muslim, even though I'm not practicing Islam,
Yeah.
or I'm going against Islam? I mean, after a while, it
Yeah.
becomes really a problem. And that's I think, what I'm sensing from
Sure.
people who talk to me about this is,
Sure.
well, how many of you are following the true Islam
Mhm.
versus how
Yeah.
many of you
Yeah.
are saying that in the name of Islam?
Yeah.
Where
I-
do you draw the line?
Good. Well, I think that's a very interesting question. Where do you draw the line? Depends on, again, on the condition, situation, on who's in charge, who's engaged in this activity, and it's a very nuanced, really, issue, and very difficult to sometimes sort out. And I think, if I may also go back to the second point, there have been attempts to, for instance, institute Islamic arbitration here in the West to deal with issues of family law and so forth, which may be consistent with the Uniform Arbitration Act in the United States. Some Muslims said, the US law may allow the establishment of a separate Islamic-based arbitration system where Muslim litigants could, in fact, go back and have their cases or their disputes resolved in an informal way, and then they can have that, incorporated in a judgment by a court in the U.S. system, which may be of some benefit to the system because there may be less caseloads, for instance, for courts. It may lessen the caseloads and so forth. The debate about that arbitration attempt, for instance, was really based on the apprehensions by some U.S. jurists here about the fact that there may not be enough guarantees in Islam for the same rights, for the rights that are due to those Muslims who are appearing before those tribunals as citizens of the U.S. because they enjoy and they are entitled to basic rights. So in the absence of such, they said, guarantees, protections, constitutional protections, we cannot subject U.S. citizens to that kind of tribunals. And that's an issue that have been tested in Canada, for instance. And Canadian Muslims successfully convinced that this arbitration is something that will be beneficial. And there will be enough safeguards against violations of the rights of those Muslims who are citizens of those countries. So that may be a model of where the US law can be enriched while its essence is not being threatened or being changed or being replaced by a foreign law. Contracts or the transactions that are based on the Islamic values, which may not otherwise be a threat to US law, I don't see any reason why those are not to be given a due consideration in US courts if they are not inconsistent with the US laws or if they do not come against the Constitution and the laws of the United States. And that's a big debate. For instance, the Jewish community do have Beit Din, which is also another religious house that allows them to arbitrate their own family affairs consistent with their religious held values. And so those are issues that come, once in a while. But that attempt has been, for instance, unsuccessful in America so far, but some Muslims have been talking about that. Those kind of things may provide some, I think, a fresh air in this kind of discussion because it will show that Sharia is not all about chopping off hands. It's not about, stoning or people to death. It's rather about a system that allows people to really have, they go about their lives and, provide maybe some solutions to their family law issues and so forth.
In the last legislative session of this Minnesota legislature, we were apparently one day or a few hours short of having an anti-foreign law bill introduced. Do either of you know more about the likelihood of that happening again here in Minnesota, or are you involved in any efforts to help legislators understand what we're talking about tonight?
Go ahead, Professor.
I have not been involved in that. I would be disappointed and somewhat surprised if it got much traction in Minnesota, just given our history and with, you know, strong groups like yours and others who are working on those interfaith fronts. But, you know, I've been surprised before.
May I say something? I happen to be the vice chairman of the Joint Religious Legislative Council in Minnesota, and we did deal with that last session, and thankfully we did manage to help stop it. It wasn't us alone. And we've been doing quite a bit of education, if you will, of the legislators, et cetera, in preparation for the new session. So that's what I
Good.
I guess a question clarifying who's subject to Sharia law. I've known some people from Egypt who told me that the Sharia law applies in a limited way mostly to family law disputes, but it only applies to Muslims. That there's a Christian and a Jewish Sharia law there that follows the rules of the Coptic Church or the Jewish congregations. That I think the fear is that Sharia law will apply to the majority of Americans who are not Muslims. But I know in Egypt, Muslim Sharia law applies to Muslims, the Jewish equivalent applies to Jews, and the Christian equivalent applies to Christians.
Yeah, well, in the Islamic history, if you look back at the Islamic history, when Islam was the dominant, religious minorities, Jewish and Christians, were given freedom to, you know, have their own separate law. They were not subject to Sharia in issues that are of purely faith issues of faith, but they were subject to the civil law of Islam as citizens of the Islamic State. And they have enjoyed same protections as Muslim citizens in most of the times, except few areas that are questionable based on some interpretations. But in general, they were subject to, for instance, consuming alcohol is a crime, it's an offense in Islam. A non-Muslim citizen of the Islamic State is not required to adhere to that law. They could consume alcohol, they could eat pork, they could have their own religious freedoms, and there are documented history of that throughout the Muslim history. But when it comes, for instance, to issues that are of common interest, such as, you know, crimes that do not involve religious issues, they are similar to and equal to other citizens as any other Muslim citizen of that Islamic State. I mean, Sharia being a system of law and a system that governs is therefore complicated. It allows for exceptions. It allows for non-Muslims, visitors who are non-Muslims, and all of that to have their own status within that system, just like we have in the U.S. I mean, we have citizens, we have permanent residents who have green card holders, who have less privilege, even though they are, you know, living among us because of the legal issues and legal basis that they have in this country. And so it's a very complicated issue, yeah, and system, sorry.
Are there other questions?
I have one question. As Professor Robson, there's some tension between Islam and the desire for it to be kind of all-encompassing in all parts of your life, and sort of the American tradition. And so you've got things like blasphemy laws, I believe are part of Sharia law, and yet we have the First Amendment right to say what we want, and other types of law, freedom of religion, for example, where if somebody wants to leave the Muslim faith, I think apostasy is also not allowed. So how do you square that with Sharia law and the U.S. law, and then if Sharia is meant to be kind of all-encompassing, isn't that what Muslims then want the United States law to look like, then, a Sharia-based law?
Well, thank you. Seems like that. Well, blasphemy law is a very, very difficult issue in many discussions about human rights. Especially, it comes back. It comes always in the context of certain practices in certain countries, especially Pakistan, which has a very strict anti-blasphemy laws called Hudud and Qisas Ordinance, which were actually enacted in 1984. And these are basically, the provisions of that ordinance says that anyone who is guilty of blasphemy law or blasphemy could be subject to punishment up to death. And almost all those who were prosecuted under that statute were non-Muslims who were sometimes unfairly targeted by other Muslims who just wanted to really get back at them. So the enforcement of that law, I think, has been much more problematic than the concept itself. Quran says, do not insult the religious beliefs of others. It prohibits Muslims from engaging in offensive language against other faiths. That's very clear in the Quran. And Prophet Muhammad himself has, in fact, laid out a clear example telling his companions that they should refrain from engaging in that kind of conduct. So it has been established a rule that nobody has, in fact, been required to, especially non-Muslims, to praise Islam or not express their views in most of the times. But what we have here, I think, is a fundamental misunderstanding of the context in which these laws are applied. I think they are very subjectively applied. I think they are laws that really do not serve the broader Islamic value of allowing people to express their own views. The Quran itself allows people to disbelieve the Quran itself if they are not convinced by it. And so to require others not to express their views. And the problem is, where do you draw the line? I mean, it doesn't, somebody might say some bad things about Prophet Muhammad, and then that all of a sudden becomes an offense. And some people take their law into their own hands to enforce those kind of punishments. So it's a very problematic issue. And it's just a reflection of really a crisis, I would say, within the Muslim jurisprudence proponents in the Muslim world, and it needs a reform in that sense. I certainly agree that the blasphemy laws needs to be reformed in order to make it compatible with the ideals of Islam as such. Issue of obesity is another problematic issue. Obesity is one of the hudud in Islam. The hudud are those punishments that are prescribed in the Quran and that have punishments that are also prescribed and specific. Obesity is a crime, according to many scholars, because it amounts to treason, as they say. It amounts to a treason, an act of treason, and therefore the person who's found guilty of that has to be punished. The reality is, there is no verse in the Quran that specifies obesity as a crime. So it's not established in the Quran. What you have is a tradition of the Prophet, the authenticity of which is questionable. So some scholars said that we consider this authentic tradition of the Prophet, and therefore it establishes a rule, and we have to therefore punish the obstates. But there's, I think, enough jurisprudential theories out there these days, and scholars who are arguing otherwise and trying to review that itself. And so again, it's one of those examples where the Islamic law is evolving, and there are different views and points of views within the Islamic jurisprudence. And therefore, I know it's in the practical life, it's very problematic issues, because many Muslim countries do have Christian minorities and Jewish minorities in some cases, maybe very few, but other religious groups as well. And this comes back in that context, and it's a very difficult issue as such, but I think it cries for reform.
And just one brief addendum to that. I think there are some important substantive discussions between Islam and Western liberalism, between Islam and Christianity and Judaism on some of these norms. So, and what I try to emphasize in my paper is what anti-Sharia legislation is doing is saying, we're not even getting to the substantive discussion. We're going to rule as out of bounds anything that emerges from this tradition, right? So, you know, what we're saying here is not, these aren't important discussions to have. It's, these are important discussions to have, so let's have them. But once you start looking to the source and saying, that's the conversation stopper, well, then you haven't served anybody's long-term best interest.
When I read the model law that this anti-Sharia law, it seems so toothless, as you kind of pointed out in your opening remarks, that I'm not sure that it does what you say. Because it seems to say, you know, you can do Sharia law stuff as long as it doesn't conflict with.
Well, yeah, so
So it's toothless, right?
the Oklahoma law did what I say. The other laws that have come after are trying to get as close to the Oklahoma law and still be constitutional. In the end, I think it's just political grandstanding, because I don't think it does anything.
We're at 5, it's 9 o'clock. There are coffee and refreshments outside in the lobby, and I think you could probably continue the conversation with the speakers. Thank you very much.
Wonderful job. Nice to meet you. Nice to stay in touch.
You were great. I learned a lot. Yeah, I love it.